Hello and welcome to this evening's Mansfield public lecture. My name is Helen Mountfield. I'm the principal at Mansfield College, and I'm delighted this evening to have a talk held on our behalf by Justice Brian Preston. Brian is the Chief Judge of the Land and Environmental Court of New South Wales, and before he was appointed in 2005, he was a barrister practicing especially in environmental law, and he's written books about environmental litigation and talked at the University of Sydney and Western Sydney University on this subject for many years as well. Last academic year, Brian was a visiting fellow at Magdalen College in Oxford, and I persuaded him to give a Mansfield public talk on climate consciousness and the law. We had a very interesting pre-discussion about the normative effect of law, how judgments don't just make the rules that people have to comply with, but inform thinking about important issues like climate change. And I was really looking forward to Brian's lecture. Unfortunately, it was scheduled for the 19th of March. And by the time we got to the 19th of March, it wasn't safe to hold a public lecture and it couldn't go ahead. But he's very kindly rescheduled for today. We'd hoped again that it would be in person, and he hasn't been able to get over, understandably. Consequently, it being 1 o'clock in the morning in New South Wales, where Brian is, we've got a recording of his lecture now, which we will play for you. But to preserve a live-ish element, he's very kindly said that if you want to ask questions in the Q&A function during or after the lecture, then he will look at those overnight and tomorrow, and we'll be able to put them up and send those answers to everyone who's participated in the seminar. So I'm very glad to see you here. I'm very sorry that we can't have the real Brian. I hope we'll have him again before too long. But this evening's talk is Justice Brian Preston talking about climate consciousness and the law.
It's been a great pleasure to be able to give this address to Mansfield College. I had hoped that I would be able to deliver this lecture in March, but unfortunately the coronavirus crisis put an end to that. We've all had to go into lockdown, and I know things have been particularly difficult in the United Kingdom. I'm not able to be there for this lecture, but instead I have recorded it for you. I hope that you find it of interest. The topic is climate consciousness and the law. I'm going to explore the interrelationship between climate consciousness and the law, and I'll do so in 3 steps. The first is a quick introduction to how the climate crisis can bring about either climate consciousness or climate blindness. The second is how climate consciousness or blindness can influence the making and content of the law. And the third is the converse, how law can influence climate consciousness or climate blindness. So let's start with the climate consciousness, the climate crisis. Now, earlier this year, 11,000 scientists declared that planet Earth is facing a climate emergency. They said that greenhouse gas emissions are still rapidly rising, with increasingly damaging effects on the Earth's climate. And an immense increase of scale in endeavours to conserve our biosphere is needed to avoid untold suffering due to the climate crisis. Now, in Australia, you probably see earlier in the year, we had devastating bushfires, the worst that Australia has ever had. That is just one example of the climate crisis. The report by the 11,000 scientists looked at what are the drivers of the climate crisis. The graphs that I've shown are extracted from their article, but they show that there are many, from the increase in human population, the increase in GDP, the increase in energy consumption, and conversely, the lack of proper laws and regulations. For example, the decrease in the carbon price. And what has been the response? Well, we've seen an increase in the carbon dioxide and other greenhouse gases such as methane and nitrous oxides. We've seen an increase in the surface temperatures. We've seen that the sort of Arctic ice and the Greenland sea mass has decreased, and so has it in Antarctica. And of course, we've seen an increase in the sea level chain, or the sea level. We've seen an increase in the area that is burnt by fires. We've seen an increase in the extreme weather and climate and hydrological events. All of these are showing that the climate crisis is real. So this corresponds with a rise of concern. So the authors say this: mitigating and adapting to climate change while honouring the diversity of humans entails a major transformation in the ways our global society functions and interacts with natural ecosystems. We're encouraged by a recent surge of concern. Government bodies are making climate emergency declarations. School children are striking. Ecocide lawsuits are proceeding in the courts. Grassroots citizen movements are demanding change, and many countries, states, provinces, and cities and businesses are responding. Now, does this necessarily lead to climate consciousness? Well, it can and it cannot. What do I mean when I talk about climate consciousness? Well, I'm talking about that we are conscious of climate change and its consequences, but we're also conscious of the need to take action to mitigate and adapt to climate change. Now, I contrast that with climate blindness. And that's an indifference, or at worst, an antipathy to climate change and its consequences, and that need to take action to mitigate and adapt to climate change. And as I show through the lecture, we'll see that there have been instances of climate consciousness, but unfortunately also instances of climate blindness. So how can this climate consciousness influence the law? Well, it can do so at three levels. One, at the international level, second, at the national and subnational level, and it could also influence the courts. And I'll explain each of these. So let's start with international law. So the climate consciousness evidently led the international community to agreeing certain treaties. The first was the United Nations Framework Convention on Climate Change in 1992. Subsequently, there was the Kyoto Protocol in 1997, and more recently, the Paris Agreement in 2015. But what we didn't see is the response that perhaps is needed. So climate consciousness didn't lead to an agreed replacement to the Kyoto Protocol. That was sought to be done at the 2009 Conference of the Parties in Copenhagen, but it didn't eventuate. We also can see that the treaties that have been agreed, including the Paris Agreement, are not action forcing as to substantive result. Although there is a temperature target in the Paris Agreement, and that is, for example, that it be well below 2 degrees Celsius above pre-industrial levels, and there's a time target of achieving these net zero emissions by 2050, they haven't actually been locked in. There's no substantive obligation on the parties to achieve those results. Rather, there's only an obligation as to process. And that is that the parties have to nominate what is referred to as nationally determined contributions to achieve these targets. But we also can see that the parties that fix these NDCs are not required to make them sufficiently ambitious to actually achieve the temperature and time targets of the Paris Agreement. Each country determines for itself what is going to be its NDC. Now, in fact, the aggregate of the NDCs that the parties have submitted under the Paris Agreement will lead to a temperature increase of more than 3 degrees Celsius, far beyond what has been sought in the Paris Agreement. Let's move to national law. So where can we see a positive influence of the climate consciousness on national law? Now, obviously, there is a need for national and subnational climate laws. We need to translate what has been agreed at international level into the domestic legal system. And that needs to take action to mitigate and adapt to climate change. Now, many countries have adopted climate laws, and there's about 1,810 climate laws and policies, according to the Grantham Research Institute on Climate Change and the Environment. And climate consciousness society has influenced legislative action in the making and content of these laws. But when you look at those laws, again, we can see a feature, and that is that climate consciousness has not driven legislative action to achieve a substantive result. It's only a process in most instances. Now, does this fact that we're having climate laws being influenced by climate consciousness mean that the laws lack legitimacy? Well, Professor Elizabeth Fisher at Oxford says no. She suggests yes, and I quote, "So environmental law is often perceived as the wild child outsider when it comes to law and governing, born itself out of a strand of left-wing populist politics in the 1960s and 70s. But while much environmental law is due to grassroots demands for democratic change, environmental law is a set of complex institutionalized practices that are grounded in a commitment to public reason and the rule of law. And this helps ensure that environmental law is legitimate." So too with climate law. I've spoken about the positive influence of climate consciousness on the law, but unfortunately, just as I said, there's climate consciousness, there's also climate blindness. And climate blindness has also led to certain action by legislatures and executives in many countries. So in certain countries, there's been a right-wing populist pushback championing climate blindness, or even worse, climate antipathy. And examples are in the United States, in Brazil, and indeed in my own country, Australia. And this has led to a regression of environmental and climate laws. So take Australia, there's been a repeal or amendment of the laws we had on a carbon tax, on renewable energy and climate change, and there's been an abolition of associated regulatory bodies for climate change. In the United States, there has been a repeal and amendment of many regulations on environmental protection, clean energy, and climate change. And there's been drastic cutting of funding and programs of the associated regulatory agencies. Now, such actions offends what is called the non-regression principle of the environmental rule of law. Inaction or inadequate action by governments to address the climate crisis has led to civil society protest, calling for urgent and aggressive legislative and executive action. We can think of the Fridays for Future movement founded by Greta Thunberg and other youth movements, but also Extinction Rebellion. It has also led to public interest litigation against governments to compel action to mitigate or adapt to climate change. And I'll refer to some of these cases later in the lecture. And this is the various countries in which climate change litigation has occurred. So now I've dealt with the climate consciousness influence on international law and on national law. I want to turn now to how it influences courts. So the climate consciousness of society can have an influence on court decisions. And this is because societal change drives legal change. A former Chief Justice of Australia, Robert French, said this: "With legal change and social change, the question may often be asked, which comes first, the chicken or the egg? In a sense, societal change always comes first. The cases which come before the courts and place demands on existing principles are a reflection of things happening in wider society. The courts do not have an agenda for promoting social change. So how can we see this influence? Well, we can see it on judicial decision-making in what has been referred to as both easy cases and hard cases. So easy cases are where there is no dispute about what the law says or how it applies to a particular set of facts. Hard cases are where there is a dispute about what is the relevant law or what relevant legislation means, or whether and how the relevant legislation applies to a particular set of facts. Now, Jeremy Waldron disputes that there really is a bright line between these two types of cases, but nevertheless, the legal literature abounds with discussion of them. So let's start with easy cases. Now, in easy cases, the courts can easily find the law and apply it. Now, legislation that they apply is normative. It fixes and directs action according to the norms embodied in the legislation. Now, environmental and climate legislation, the norms in the legislation may reflect climate consciousness of society. So, in these easy cases, when courts apply the obviously applicable legislation, they also apply the norms of society that are reflected in the legislation. Now come to hard cases. So hard cases are where there are no existing legal rule that's immediately applicable, and so courts need to find and interpret the legal rule that is to be applied. Now, there are different views as to how this is done, and I'm going to compare two jurists, Hart and Dworkin. Now, Hart suggests that judges do make law, and that's legitimate. But Dworkin suggests that judges do not make the law, but instead only find the law. But as I'll show in a minute, either way, judges do take into account moral considerations, whether they're making or they're finding the law. And these moral considerations include society's attitudes, which can include climate consciousness. So let's just elaborate a little bit on those two approaches. So let's start with HLA, Hart's approach. And here it gets a bit technical, but bear with me. So to start off with saying that law is a system of rules. There's both primary rules and secondary rules. The primary rules are the rules that generate duties or obligations that are posited by legislation and common law. The secondary rules are rules of change, adjudication, and recognition. And these are the ones I want to explore. So firstly, rules of change. Rules of change facilitate legislative or judicial change to both the primary rules and certain secondary rules, such as the rules of adjudication. Now, this process of change is regulated by secondary rules that confer power on individuals or bodies, such as Parliament, to change the primary rules in accordance with certain procedures. Come to rules of adjudication. These confer authority on individuals and groups, such as judges, to pass judgment, mainly in cases of breach of the primary rules and to sanction and remedy the breach. And the final set of secondary rules are rules of recognition. These determine the criteria by which the validity of all rules of a legal system is decided. Rules of recognition impose a duty on those who exercise public power, particularly judges, to follow certain rules. But so too, officials in the legal system must accept the rules of change, adjudication, and recognition. Now, let's apply those rules to the system. Every system of rules will leave some situations unregulated, and this is a consequence of the open texture of language that is used in describing the rules. There will be some clear cases where a rule certainly applies. Hart refers to this as a core of certainty. But many cases where there is doubt as to when and how the rule applies. This is what Hart refers to as a penumbra of doubt. Now, in these penumbral cases, the decision to apply the rule or not cannot be determined by the rule itself. Why? Because the rule is indeterminate in application to the penumbral case. So if you can't only look at the rule, you've got to look outside the rule. So penumbral cases need to be resolved by the judge taking into account extra legal considerations of justice or social policy, such as moral considerations, as a basis for deciding whether the rule ought to be applied or not, and in developing a new rule that is apt to the case at hand. Now, how do we develop the line of law? Well, Benjamin Cardozo suggests that the judge, in developing a new rule, can do so along 4 different types of lines. One he calls the line of logical progression, and this is the one most commonly used, the rule of analogy. The second is the line of historical development. The third is the line of customs of the community. And the third is the line of justice, morals, and social welfare. Now, the secondary rules, that is, of change, adjudication, and recognition, empower the judge to give authoritative binding decisions on such issues so as to resolve the penumbral uncertainty. And the judge's decision makes law in these situations. That is, the judgment once given becomes a source of law. Let's contrast that approach to Dworkin's approach. Now, Dworkin says that in deciding a hard case, courts do not make new law at all. He says all of the resources for a judicial decision are provided by the existing law, as correctly understood, and that's the critical point. These resources include the explicit settled law, what he calls the rules, as well as implicit non-rule standards, principles and policies that underlie and are embedded in the settled law. Now, together, these existing legal resources, the rules and principles and policies, make up a seamless web. There is no law beyond the law. There are no gaps in the law. So the task of the judge is to understand the content of this legal system and give effect to it in their judgments to the best of their ability. Now, the task is interpretive, but it is also evaluative. It involves identification of the principles that both best fit or cohere with the settled law and legal practices of the legal system, and also provide the best moral justification for them. And that shows the law in its best light. So the judge favours an interpretation that allows the law to fit most comfortably with the spirit of the rest of the law and with the principles and ideals of law and legality in general. So deciding on what law is, therefore, depends on moral political considerations. So we can see that under either HART'S approach or Dworkin's approach, whether we make the law as HART suggests or we find the law as Dworkin suggests, judges do take into account considerations of justice, social policy, and moral standards. Now, climate consciousness of society can influence these considerations. So societal change can place demands on the court's adjudicative function. I want to now look at the problem from a different way. There are 3 branches of government: the legislature, executive, and judiciary. And I want to see how the exercise of their functions can influence the law. Let's get a little bit of light here. Now, the 2 sources of law that I've spoken about, firstly the legislature and secondly the judiciary, can raise or lower climate consciousness. But so too the executive branch of government, in executing and enforcing the law, can raise or lower climate consciousness. And I want to explore each of these organs of government. So we'll start with the legislature. Now, as I've said, legislation is normative. It fixes and dictates action according to the norms in the legislation. Now, Lon Fuller suggested some desiderata of legal rules. And he said that in order to counter law, one of his desiderata is that they be publicly promulgated. And this involves publication. Now, publication of legislation promotes awareness of the law and what the duties and obligations the law imposes. Now, the vast majority of people and officials do actually comply with the law. There are a few who do not comply with the law, but they can be prosecuted and punished. And their prosecution and punishment is public. And this process also publicizes the law and the duties and obligations in the law. So either way, the publication of legislation and the following of that by people who do comply with the law, but also the prosecution and punishment of people who do not comply with the law in public, shapes people's and officials' normative attitudes and behaviours. Come to the second organ that makes law, the judiciary. And I want to say four ways in which the judiciary can play this role. The first is that courts obviously uphold and enforce the law. They do this by declaring and upholding the law, and they sanction and remedy breaches of the law. But secondly, at a more general level, courts uphold the rule of law. In public law cases, for example, courts can hold the executive branch of government to account, directing compliance with environmental and climate laws. The third way is that courts enhance democracy. And I'll give two ways in which this can be seen. The first is judicial review of administrative action or inaction. That can enhance democratic processes, including public participation, and the quality of public administration by compelling the executive branch of government to comply with the will of the legislature expressed in the legislation. The court's decision can also bring scrutiny to bear on the deficiencies of the law and its execution. So the judicial remand brings matters to legislative and executive attention, and it forces them onto their agendas. And the fourth role that court play is to uphold norms. As I've said, the court's decisions publicize and promote the norms in the laws, such as the legislation. But the courts also, in making or finding the law, in the ways I've explained by Hart and Dworkin, can expound norms. So this means that courts' decisions can raise climate consciousness. So the courts, when they adjudicate climate litigation, can raise climate consciousness of society, and they could also inspire other climate litigation. I've referred to this as the ripple effect. And I'll just give you some of the recent cases around the world which shows how the court decisions can raise this climate consciousness. The first is the well-known case brought by the Dutch environmental NGO, Agenda Foundation, against the Dutch government. They sought a declaration that global warming of greater than 2 degrees Celsius would lead to fundamental violations of human rights worldwide. And they sought a declaration that the Dutch government was acting unlawfully by not contributing its fair share to prevent global warming. And so they sought orders that the government reduce the emissions in Netherlands by 40% or at least 25%. Now, the Agenda Foundation was successful at each tier in the judicial hierarchy. At first instance, the Hague District Court held that the Dutch government had acted negligently in its duty of care and ordered it to reduce the country's greenhouse gas emissions. On appeal, the Hague Court of Appeal upheld that decision, but they did so on other reasons, including on human rights law. And finally, the Supreme Court of the Netherlands upheld the Court of Appeal's decision on human rights law. Now, the agenda decision has had a ripple effect. It has inspired a very similar action in Belgium. It inspired action by law students in New Zealand, and it's seen action in Germany and in Sweden. Another high-profile case is the Juliana case. This is one of a number of cases brought by an environmental NGO called Our Children's Trust. And they have been taking action in many states and at federal level in the United States. The Juliana case, just one of them, has been referred to as a youth climate case. And they were seeking to hold the US government accountable both for its failure to take action to mitigate climate change and its affirmative actions in promoting and approving fossil fuel development in breach of its obligations. They're the plaintiffs. Now, their action was founded upon two grounds. One was a violation of the plaintiffs' explicit and implicit constitutional rights, and the second was on the concept of the public trust doctrine. Now, that second limb, the public trust doctrine, has been picked up and has inspired many actions around the world. So there's been actions in the Philippines, Pakistan, and India as just some examples. The first cause of action about the right to a quality environment has also inspired action around the world. So in Norway, there's been an action by Greenpeace, in Ireland by the Friends of the Irish Environment, and in Colombia by, again, youth plaintiffs in the Future Generations case. And this aspect of the case is important. That is, it's not only the causes of action that were invoked in Juliana, it's also the significance of using youth plaintiffs, because they are taking action against the present generation, saying that they are endangering the human rights and life of future generations. And we've seen a number of these cases around the world. And I picked out some of those. I referred to the one in Colombia. There's been ones in Canada, Pakistan, India, and also actions under the Convention on the Rights of the Child. The final case I want to refer to was in fact a decision of mine about the Crocky Hill mine. It was a Gloucester Resources case. And there, a mining company sought to develop, operate, and then ultimately rehabilitate an open-cut coal mine. The government had refused the application. There was an appeal to the court. And a community group joined the proceedings and raised the impacts of the mine on climate change. And amongst other reasons, the court decided to refuse the mine for its impacts on climate change. That too has had a ripple effect. It's been picked up by and discussed in Australia and around the world. One commentator said that climate change is no longer a niche issue. We're increasingly seeing instances similar to this decision where courts are incorporating climate change into their fact-finding and reasoning as they would with any other matter. These developments are having far-reaching and rapid consequences for decision-makers in the public and private sectors. And another commentator said the decision was getting attention outside of Australia. Climate litigation is emerging everywhere around the world, meaning that people have an interest in seeing what courts in other countries decide. So these climate change cases that I've referred to tend to feed off each other. So where you see the law moving into areas that are new, it's not uncommon for plaintiffs and judges alike to look across the borders for examples of relevant precedents. And the Gloucester case has been used in a couple of cases, one in the United States and another in Canada. Let me move now away from the legislature and the judiciary's role to the executive's role. Now, the law, whether it's in the legislation or as common law, is executed by the executive branch of government. And the implementation and enforcement of the law affirms and publicises the norms embedded in the law. But so too, the executive can make policy to structure and guide its implementation and enforcement of the law. The executive can make policies for mitigation and adaptation of climate change. Now, the executive's actions in executing the law and making policy can promote climate consciousness. But also, the executive's policy can be incorporated by the legislature into the law and therefore acquire the force of law. So legislation may require administrative decision makers to consider government policy either generally or a particular policy. And once the policy is adopted, it then becomes a mandatory consideration. So an example was a recent decision in the United Kingdom under the Planning Act. And this was the Heathrow third runway case. So there was, under the UK Planning Act, Section 5, subsection 8, it requires that the reasons for the Secretary of State designating a policy a national policy statement must include an explanation of how the policy set out in the statement takes account of government policy relating to the mitigation of and adaptation to climate change. So in the Heathrow third runway decision, the Court of Appeal held that the government's commitment to the Paris Agreement was part of government policy, and hence the Secretary of State was required to have taken into account that policy in designating the airport's national policy statement as a national policy statement. So you can see here how policy can be incorporated into the law and given the force of law. Now, the executive, although it may adopt a policy to mitigate or adapt to climate change, could fail to implement that policy, and this could lead to a breach of law, such as a violation of human rights. An example is in Pakistan. The Pakistan government had adopted national policies for adaptation to climate change, but it failed to implement them, and that caused a violation of people's human rights. The Lahore High Court ordered the government to take specified actions to implement the policies and thereby remedy the violation of the petitioning farmers' rights. So to here, we can see that the executive's policy can have legal effect. I come to my conclusion. The climate crisis requires urgent and ambitious action to mitigate and adapt to climate change. But the will to take such action must exist, and this requires a change of mindset. As Ursula Le Guin observed, changing our minds is going to be a big change. To use the world well, to be able to stop wasting it and our time in it, we need to relearn our being in it. Or, as Mahatma Gandhi advised, we need to be the change we want to see. The actions we take will be defined by the mindset we have before we take action. Now, Christiana Figueres and Tom Revet-Karnak, in their book that was released earlier this year, The Future We Choose, Surviving the Climate Crisis, posed the choice facing us in this language. Who we understand ourselves to be determines the choice we will make. The choice determines what will become of us. The choice is both simple and complex, but above all, it is urgent. Attempting change while we're informed by the same state of mind that has been predominant in the past will lead to insufficient advances. In order to open the space for transformation, we have to change how we think and fundamentally who we perceive ourselves to be. Now, they advocate the adoption of 3 mindsets, which they entitle as follows. First, stubborn optimism, and that is to take action and to make a difference. Second, endless abundance, rejecting individual competition under the zero-sum paradigm in favor of collaboration to satisfy collective needs and wants. And thirdly, radical regeneration of ourselves and nature, shifting our action compass from self-centric to nature-aligned. Now, the adoption of these mindsets will change the future of climate law and governance. Thank you for your attention. I'm happy to answer some questions if you would like to pose them online.
Well, although I hope he's now soundly asleep, I'd like to thank Brian very much for giving that fascinating and thought-provoking talk. I particularly like the idea of stubborn optimism. It's something which today in particular I'm clinging to. And also an idea that I wish I had appreciated when I was studying law, how important it is to examine the mindsets which have created the law and to realise how they do change, and particularly the borrowing from one culture to another. It's certainly very important for lawyers in developing fields like environmental law to be aware of the movements around the world and the conversations that are happening. And in all the areas of law where there have been very radical transformations, and climate change law is certainly one of them. Gender rights is another I can think of, where things change very fast in my career lifetime all around the world at very much the same time. It really is an important conversation to have about the extent to which the law informs the political and normative climate, and in which the climate informs the law. I'm going to leave the chat function, the question and answer function open just for a couple of minutes after this talk, so that if anyone does have questions or observations they'd like to make to Judge Preston, he will be able to answer them either individually by email, or we'll send around any answers to questions which people may have over the next day or two. But thank you, Brian, for giving this talk, and thank you all very much for listening and participating. Good night.